Welcome to Business Law course. This is Sujana speaking. This is the second part of intellectual property law topic. In this part, we will discuss about the classification of intellectual property. During the development of intellectual property, there has been several classification. You could read the history and the development of intellectual property in various references, and one of the recognition or the classification of intellectual property is from General Agreement on Tariff and Trade, or GATT. According to GATT or GATT, the classification that recognized as intellectual property are those following types. The first one is copyright and related rights. Second one, trademark, service mark, and trade names. Third one is geographical indication, followed by the industrial design, as well as patents, including the plant variety, and also the layout designs of integrated circuits, and protection of undisclosed information, and also the last one is control of anti-competitive practices in contractual licenses. This classification would be the initiation of the classification of intellectual property in Indonesia, though not all those classification is included, even though all of them is regulated in Indonesia. For example, like control of anti-competitive practices is more like a sui generis. Sui generis means it has its own set of regulations out of the intellectual property scope, which we called as the unfair business competition law, while the other is in the scope of intellectual property regulation. But yes, of course, they are related, the intellectual property and unfair business competition. So in Indonesia nowadays, right now, we admit this classification of intellectual property. We admit copyright and related right. We also have the regulation of patent, and also the trademark law. We also have the industrial design regulation, and our country also governs about the geographical indication, the trade secret, the protection of new plant variety, and the integrated circuit. About the control of anti-competitive practices, unfair business, it has its own law, which we call as the law of anti-monopoly and unfair business competition, law number 5, 1999. So those are classifications of intellectual property in Indonesia. We will discuss about each of them at the specific part as the continuation of the discussion of intellectual property topic. So that is the classification of intellectual property in Indonesia, and also the closing of this part. At the next part, we will start with copyright and followed by the other classification of intellectual property. See you at the next part, everybody. Ciao.